in person and to those who are attending online. It's terrific to see such a good turnout, and the number of attendees, both in person and online, is a testament to the importance of this practice area in the Federal Court's jurisdiction. We are on the country of the people of the Kulin Nation here in Melbourne, and on behalf of the Court, I offer my respects to them, to their elders, and to all Aboriginal and Torres Strait Islander people who may be here or listening online. Thank you to my colleagues, and particularly Justice Rangia, for organising this seminar and chairing it tonight. Now, this is not an audience that needs any reminder about the importance and vitality of employment and industrial law to the jurisdiction of this court since its inception. In a speech given shortly after the establishment of the court, our first Chief Justice, Sir Nigel Bowen, nominated the court's jurisdiction under the then Conciliation and Arbitration Act, along with the court's jurisdiction under the Trade Practices Act and in respect of appeals from the Administrative Appeals Tribunal, as the three major areas of regulation of the Australian community in which this court was engaged. So it remains, as we have all been reminded today with the publication of the High Court's orders and reasons in Qantas Airways and the Transport Workers Union. We have a talented and learned lineup of speakers, and I'm sure you will enjoy what they have to say. I had hoped to stay and listen to what everyone had to say, but sometimes the demands of this job are unpredictable, and one of those unpredictable demands arose about 15 minutes ago, so I'm going to have to try and watch online if I can. But before I hand over to Justice Rangia, tonight is the right time to mention one more matter. This month, September, saw my colleague, Justice Morty Bromberg, take up in earnest his full-time role as President of the Australian Law Reform Commission. Justice Bromberg has been one of the leaders of employment and industrial work on this court, as he was at the bar. His contribution has been enormous, and there will be other occasions on which to thank him more formally for his service. But I could not let tonight's event begin without, amongst those who know better than anyone, acknowledging our gratitude for his dedicated, careful and thoughtful judicial work in this area. And he's here, so let's give him a round of applause. Justice Rangia.
Thank you, Chief Justice. About 750 legal practitioners are viewing this event, either in person in Melbourne, Adelaide and Sydney, or online. That response reflects the great significance of this area of law. There are over 15 million people in the workforce in Australia, and work is such a fundamentally important part of the lives of all of us. The cases brought by practitioners and the decisions made by the court are capable of affecting the lives of so many people. So as the Chief Justice has said, we regard our annual Employment and Industrial Relations Seminar as a very important event in the life of the court. For a number of years now, the seminar has been driven and organised by Justice Bromberg, who has traditionally presented a review of the statistical information concerning this practice area. I'm going to do my best to channel the spirit of Justice Bromberg this evening. Now, the first slide we have shows the total number of employment and industrial relations matters filed in the Federal Court over the last 5 years. The only thing to note is that the filings have remained fairly constant, with perhaps some drop-off in 2021, 2022 during the pandemic. This slide shows the total employment and industrial relations filings in the Federal Circuit Court and Family Court of Australia over the last 5 years. What is interesting is that there has been a significant decline in the number of filings, from a peak of about 1,500 a year to the present level of about 950 per year. The large drop in 2021-22 can probably be attributed to the pandemic, but even after that, the numbers have not risen back to their former levels. Apart from the pandemic, other causes seem to have been a significant drop in matters being filed by self-represented litigants, and also by several firms that were previously prolific in their filings. Now this slide shows employment and industrial relations filings by state over a 5-year period. What is notable is the change in relativity between filings in New South Wales and Victoria. So you can see that in the 2018-19 and 2019-20 years, there were significantly more matters filed in Victoria than there were in New South Wales. That started to change in 2020-21, and the trend has continued. We've seen both an increase in the number of matters filed in New South Wales and a significant decline in the number of matters filed in Victoria. The next slide shows the filings in the FCFCOA over the same 5-year period, and you'll see the same trend in terms of the change in relativity between New South Wales and Victoria, with a significant decline in the number of matters in Victoria. No doubt as practitioners, you'll have a much better understanding than we do as to why this trend has occurred. The next slide shows the numbers of matters filed in the different practice areas of the Federal Court over the last 5 years. You'll see that by far the highest number of matters are filed in the corporation's national practice area. And you'll see employment and industrial relations marked in green on the graph. It provides the third highest volume of our cases. It's only just shaded by migration by about 1%. But what the graph demonstrates is the great significance of employment and industrial relations to the overall work of the court. The next slide shows the types of employment and industrial relations matters that have been filed over the last 2 years in the court. One thing it does demonstrate is the dominance of employment matters over industrial matters. The highest volume of employment claims has been general protections, and that is followed by claims for breaches of terms and conditions of employment, which are breaches of national employment standards, awards, and enterprise agreements. The next slide shows the lengths of trials in the Federal Court. The vast majority have been 1 to 2 day or 3 to 5 day trials. However, a significant minority takes between 6 to 10 days, with a smaller minority taking over 11 days. The length of trials generally also reflects the length of times for judgments to be delivered, with the vast majority of judgments being delivered within 3 months or within 3 to 6 months. But longer trials seem to generally result in longer timeframes to judgment, broadly along the lines of the graph that you've seen. Now, the final slide I want to show you shows the average time taken between filing a matter and reaching trial. It does show an unfortunate trend of an increasing time to reach trial over the last 5 years. There appear to be a number of possible explanations for this. One is that there may be still some residual effect from the pandemic. During that period, the pace of mediations and proceedings generally slowed significantly, and there may still be a catch-up effect operating. Another possible explanation observed by some of my colleagues is the trend of parties to take a more leisurely approach to advancing proceedings. And often this seems to start with the pleadings. It can often take 3 or more months in our experience for the parties to have their pleadings in order. And then we often seem to get applications for extensions of time to comply with procedural steps without real explanation of why the steps haven't been complied with. Perhaps another reason that judges might be that proceedings might be taking longer to get to trial is that judges might be more inclined these days to order several mediations at different stages, conscious that this is a no-cost jurisdiction, and the process of mediation can take 2 or 3 months at a time. Yet another cause might be the rise in the number of class actions, which take longer to reach trial, and you'll hear about that later on today. Another cause may be the retirement of a number of experienced judges in this practice area over the last 5 years or so. Recently, however, there have been several appointments of judges with particular expertise in employment and industrial relations, so that will help. Nevertheless, the increasing time to trial is a concerning statistic that will have to be closely monitored and analysed by the court. Now, the format of the presentations this evening will be that we'll have 2 presentations in Melbourne, followed by a presentation in Adelaide. If there's time, we'll take some questions and answers at the end. The importance of the role of the FCFCOA in the area of employment law can't be overstated, demonstrated by the statistics that show that the vast bulk of cases in this practice area are filed in that court. So I'm pleased to say that we have 2 eminent judges from that court to speak about the important topic of adverse action claims. Please welcome Judge Jonathan Forbes and Judge Amanda Mancini.
Thank you very much, Justice Rangia. Perhaps if I continue the theme of facts and figures, let me focus for a moment or two on the general protections applications which are commenced in the 2 courts. As most of you will know, the Federal Court and the Federal Circuit and Family Court have concurrent jurisdiction in matters commenced under the general protections provisions of the Fair Work Act. Between the 2 courts, there were about 640 applications filed last year. Next slide, please. The figures for the last 3 years will give you some idea of the activity in the different registries. As you'll see, the vast majority of adverse action claims are commenced in the Circuit Court. Of the nearly 1,800 proceedings commenced over the last 3 years, nearly 9 out of every 10 claims were initiated in the Circuit Court. The vast majority of claims allege adverse action taken because of the exercise of one or more of the workplace rights prescribed by Section 341(1) of the Act. A lesser but still significant number of applications allege adverse action on account of one of the grounds of discrimination under Section 351, due to the engagement in industrial activity under 346, or under the coercion and misrepresentation provisions of Part 3(1). Currently in Melbourne, but not presently in other registries, the 2 courts operate an adverse action list, which is overseen by one of our shared judicial registrars. Fortnightly, between 10 and 15 new matters are listed for an online first return, usually within about 4 to 6 weeks of having been filed. At the first return, matters are triaged to ensure that they are in the appropriate court, particularly having regard to the quantum and complexity of the claim, and to ensure that the resources of the court, particularly in terms of mediation, can be best targeted toward the most appropriate matters. At these first returns, about 70% of the matters proceed by way of consent orders, and for the balance, the registrars are able to deal with procedural matters such as issues with service, applications for extension of time, appearances by non-lawyers on behalf of corporate respondents, and other interlocutory matters. Now, the data reveals that a good number of adverse action claims are successfully resolved by mediation, particularly mediation facilitated by the excellent and very experienced registrars of the court. Where mediation is ordered, the average time from filing to a mediation is about 6.5 months. Next slide, please. A little over half of the matters which are referred to a court-ordered mediation are successfully resolved. And that statistic is fairly uniform across the 2 federal courts. Quite often, orders for mediation are sought by practitioners at the first return, but the registrars presiding over the list are astute to balance the resources of the court and the prospects of resolution, particularly having regard to the fact that in many cases, or in most cases, the parties will recently have attended a conciliation conference before the Fair Work Commission. I'd like to turn then to some observations about adverse action applications, which do make it to trial, but I can only touch on a few. Next slide, please. First, self-represented litigants. A significant number of matters which get to final hearing in the circuit court involve one or other party being self-represented. And it's not only applicants. Not infrequently, directors and officers seek leave to represent corporate respondents, often citing the prohibitive cost of lawyers as the reason. For a trial judge, self-representation brings an array of complications and case management challenges, including lack of legal knowledge or an overconfident command of self-taught law, non-compliance with court orders, unfamiliarity with the rules of evidence, court procedures and etiquette, and unfocused cross-examination and submissions. Justice Bromberg's regularly cited caution in Ermel and Dulux Group that a general protections proceeding is not a broad inquiry as to whether the applicant has been subjected to a procedurally or substantively unfair outcome often goes unheeded. And the fine line between an unlawful dismissal and an unfair dismissal is easily crossed. My fortunate experience has been that counsel usually have the patience and the wherewithal to assist the court and the self-represented litigant through these challenges without compromising the interests of their client. But that is not always the case. Next slide, please. Clear pleadings and case outlines are necessary for the efficient conduct of adverse action litigation, but this too often proves to be a luxury. It's not uncommon in adverse action cases to be commenced by long narrative pleadings, which are hard to distinguish from affidavits. These claims often reveal a very poor understanding of the elements of a general protections action and where the onus falls to be determined on certain matters. The alleged workplace rights, the alleged adverse action, and the alleged prohibited reason are often confused or conflated or obscured by opinion and argument and submission in a document which represents itself as a statement of claim in name only. And let me be clear, this is not a problem limited to self-represented litigants. Turning now to a couple of the more interesting legal issues, which are commonly the focus of debate in adverse action litigation. Next slide, please. Establishing a workplace right or its exercise is a matter for which the applicant bears the onus. In recent years, the statutory requirement that a complaint or inquiry be one that the employee is able to make has been the subject of much judicial consideration in the federal court at single judge and appellate level, but not all of it has neatly aligned. It'll be recalled that in the seminal case of She and True Energy, Justice Dodd-Streeton observed that the requirement that the complaint be one that the employee is able to make in relation to his or her employment suggests that there are complaints which the employee is not able to make in relation to his or her employment. The ability to make a complaint does not arise simply because the complainant is an employee of the employer, and so on. Her Honour's observations have been frequently endorsed at full court level, but successive judgments have been unsuccessful in painting a bright line between those complaints an employee can make and those he or she cannot, understandably. Fortunately, some, but not all of the uncertainty was quelled a year or so ago by the full court decision in Alam and National Australia Bank, which, after a very fulsome survey of the divergent views of various members of the court, emerging from a long line of previous conflicting authorities, including Cigarette and Gift Warehouse and Whelan, and PIA Mortgage Services and King. So as things currently stand, post-Alam, an employee may have the requisite ability to make a complaint or inquiry, not only by reason of a workplace law, a workplace instrument, or an order made by an industrial body, which are the entitlements referred to in section 341, 1A and B, but also from legislative provisions which are not workplace laws, contractual terms providing a right to make complaints, and from the general law. But among the long line of authorities which preceded Alam, there have been a number of articulate dissenting views and obiter by senior and experienced members of the Federal Court who have variously expressed both narrower and more expansive views on the issue of complaints that one is able to make. In this morning's High Court decision in Qantas and TWU, Justice Stewart, at paragraph 116, I have read it, took a lone excursion into this issue. The other judges didn't see it as necessary, but he expressly endorsed the reasoning in Whelan as being plainly correct. So I'd suggest that you read that paragraph because I think it is the first High Court utterance on the issue. And he cites at footnote 107 the full history of cases. But what has not been disturbed is Justice Dodd-Streeton's notion that there remains a species of complaints and inquiries which an employee is not able to make. And as Justice Snowden recently observed in Messenger and Commonwealth of Australia, it is not sufficient that a complaint or inquiry is made simply because the employee feels, with good justification or otherwise, that he or she has something about which to complain or inquire. Perhaps His Honour had almond milk in mind. In adverse action cases, the nuanced differences of judicial opinion invites ongoing debate about whether certain complaints or inquiries are ones that an applicant is able to make for the purposes of the general protections provisions of the Act. And I see no end to that. As a humble circuit court judge, I'm acutely aware of who will be marking my homework. So these divergent judicial views and musings make for very interesting reading. Anyway, I can only flag this as an ongoing issue, encourage you to read the authorities, and I'll leave exploration of it to another day. Next slide, please. A more vexed question is the search for the subjective intent which actuated the respondent to take the impugned adverse action. Now, that of course is an issue which is always contested. The court's factual inquiry must answer the question, why was the adverse action taken? And that is a matter in respect of which the respondent, not the applicant, bears the onus. The rebuttable presumption in section 361 of the Fair Work Act presumes that the relevant act or conduct of the respondent was taken for a prohibited reason or with a prohibited intent, unless the respondent proves otherwise. The interesting legal and practical question in any given case is, how is that onus to be discharged and what evidence is necessary to do so? Now, to state the obvious, a corporate entity has no mind of its own. Where it's alleged that a body corporate has engaged in unlawful adverse action, Section 793 of the Fair Work Act serves to attribute to the entity the conduct of the human agents through whom it acts, and in certain circumstances, the state or states of mind with which they did so. Accordingly, the respondent entity must positively establish through the evidence of human actors that the alleged exercise of a workplace right or workplace rights did not factor in any substantial or operative way as a reason for its decision to effect the adverse action. In relation to how an employer might rebut the statutory presumption, we all recall the statement of Chief Justice French and Justice Crennan in Bendigo, Tafe and Barclay, which, to paraphrase, was that the question, that is, why was the adverse action taken, is one of fact, which must be answered in light of all the facts established in the proceeding. But generally, it will be extremely difficult to displace the statutory presumption in section 361 if no direct testimony is given by the decision maker acting on behalf of the employer. And they went on later in that well-read paragraph that, however, direct testimony from the decision maker, which is accepted as reliable, is capable of discharging the burden on an employer. The High Court's decision in Barclay served to reinforce that the inquiry must be directed to the actual reason in the mind of the person who made the decision and took the adverse action. In Barclay, there was a sole decision maker, the Chief Executive Officer, whose subjective state of mind was the subject of the inquiry. There followed a series of cases which will be familiar to many or most of you, including BHP Coal, Endeavour Coal and Hall, which maintain this focus on the mental processes of the person who took the adverse action or whose decision was immediately responsible for the adverse action. In these cases, the decision maker and the actor were one and the same. In the mind of some practitioners, the High Court in Barclay set a template for what has become the conventional line of defence in an adverse action claim. There's been a tendency in many cases on the part of respondent employers to present a particular human actor as the or the sole decision maker, and to plead that person's subjective state of mind as the state of mind of the respondent. Many a respondent's case has been built around the concept of a single responsible decision maker, often a clean-skinned senior executive who possessed corporate authority to approve or effect the adverse action, but who was otherwise quarantined from the layers of management bureaucracy and processes which led to it. Based on decisions such as ABCC and Hall, the prevailing view was that circumstances which arise externally to the mental processes of the decision maker or makers is irrelevant to the court's inquiry. However, the ghost of Elliott and Kodak Australia has never been far away. In Kodak, during a redundancy selection process, an individual provided information to his superiors on which the latter proceeded to make a termination decision without investigating the reasonableness, truth or accuracy of the information. In Kodak, the full court held that an inquiry into the reasons of a corporate entity may require an examination of the states of mind of human actors other than the single individual having the authority to bind the corporation in the relevant act. What the full court explained in Kodak was that where there are other individuals who contributed to the decision-making process to a sufficient degree, and where the person or those persons acted for a prescribed reason or with a prescribed intent, and where the decision maker acted on the basis of information provided by them, then the state of mind of the individuals who supplied the information is relevant. Now, this expansive inquiry, encouraged by Kodak, has been the subject of some renewed judicial interest. In cases such as Claremont Coal, Australian Red Cross, Wong and National Australia Bank, Qantas and TWU, and so on. Last year in Wong and National Australia Bank Limited, a full court endorsed the proposition that emerged from Kodak. What the court said in Wong is that it may be convenient to refer to the person whose conduct directly visited the adverse action on the employee as the decision maker, but his or her decision-making processes may incorporate the state of mind of other people, including by adopting facts or opinions asserted by them. The cases illustrate that a person who does the act or thing constituting the adverse action may act on information or advice, the provision or content of which is actuated by a prohibited reason. The adoption of such information or advice may necessitate the conclusion that the corporation's reasons for the adverse action include that prohibited reason. In such cases, it matters not that the person providing the information and advice does not formally possess the authority or power to affect the decision making or to affect the decision based on that information or advice. Whether the person actually performing the act constituting the adverse action is aware that he or she is acting on information or advice given for a prohibited reason may not be relevant. So where things currently stand, in assessing the reasons for which adverse action was engaged in, the court must interrogate not merely the state or states of mind of the person or people who engaged in it, but also that of others whose contribution to the conduct rose beyond a certain threshold level. That threshold level is a matter of debate, but the authorities tell us that it is where information has been indispensable or material, significant, plainly important, major, substantial or essential to the ultimate decision. And interestingly, this is also an area on which Justice Stewart explored this morning in this morning's Qantas decision at paragraphs 104 to 113. Next slide, please. These recent cases present a legal and practical conundrum for employers and their representatives in adverse action litigation. Do employers continue to plead the small target defence that is run with a single decision maker and press the argument that only that person had authority to make the decision and affect the adverse action, and that only the subjective state of mind of the corporation resides in that person's head? But if the evidence points to others being involved at some threshold level, then that may, in and of itself, be enough to scuttle the pleaded defence, particularly if those other persons are not called. A Jones and Dunkell submission might be irresistible to an applicant, and an absent witness might be fatal to discharging the reverse onus. Alternatively, does an employer choose to run the belts and braces defence of calling every single person who may have a fingerprint on the decision or the taking of the adverse action? Or does the answer lie somewhere in between? The conundrum's particularly acute in those cases where a decision is based on the recommendation or observation of others, such as human resources, or where the impugned decision is the product of a collaborative decision-making process, such as by a board or a committee. But faced with the rebuttable presumption created by Section 361, the challenge for employers is who you're going to call. On that note, I now turn to my colleague, Judge Mancini, who will share some other recent developments in the Court's Fair Work jurisdiction.
Thank you, Judge Forbes. And the beneficiary of the other Fair Work litigation update, I'm going to give an update on small claims. I appreciate that for many practitioners in attendance today, small claims probably rarely come within your purview. But before your eyes glaze over, just bear with me and I'll take you through why we anticipate the recent expansion of the jurisdiction is likely to be of interest for a few commercial and practical reasons. If we could turn to the first slide, please. By expansion, I'm referring to the recent increase in the threshold that applies to Fair Work claims that can be brought as a small claim. Effective on 1 July this year, that threshold is $100,000, which represents a five-fold increase on the former $20,000 cap. On the one hand, that single change doesn't sound particularly groundbreaking, but viewed in context, the value of compensation that may be ordered is greater than the average Australian annual salary and more than double the average Australian's personal median income. This increase alone is also anticipated to mean fundamental changes to the issues in and methods of resolution of small claims. So just starting from the top, while an underpayment claim can be originated in the Federal Court, in the Federal Circuit and Family Court, an applicant can elect to pursue recovery of employment entitlements as a small claim, with quite the difference in procedure. If we could go to the next slide, please. The types of small claims that come before the court for determination include certain disputes about casual conversion and the non-payment or underpayment of certain employment entitlements that are outlined here on this slide. There are some important limitations in terms of available relief. For example, an applicant who elects to proceed as a small claim cannot obtain penalties for contraventions, and they can't add a general protections claim to the mix. A small claims applicant can obtain compensation and only if referred to a judge, declaratory relief. As practitioners, you might be wondering, where do the lawyers fit in? And in many respects, they don't. But at a purely commercial level, that can be explained by the $20,000 cap on quantum, together with the no costs provision, the application of which has typically not lended towards investment in representation of applicants and respondents alike. Indeed, the court's data shows that the overwhelming majority of applicants and respondents in the past have not had representation by a lawyer. However, beyond the pure commercial drivers, there's also a feature of the jurisdiction which could explain this underrepresentation of lawyers to date, which is the matter of leave. Leave is not required for an employee or officer of any party to the proceedings. So, for example, leave is not required for a union lawyer where the union is the applicant. Otherwise, a party may not be represented other than with leave of the court. But that is not to say that leave would not be granted in an appropriate case, and anecdotally at least, when leave is sought in our jurisdiction, it regularly is granted. The newly expanded jurisdiction may well even justify the grant of such leave, which can be done on conditions designed to ensure no unfair disadvantage. To understand why, it's perhaps instructive to understand some of the other special features of the jurisdiction, in addition to the sage points that my colleague made earlier. But first, we have a claim of this nature, which can result in enforceable orders to pay compensation up to the significant amount of $100,000 plus interest. Second, the applicant may be a union or inspector and experienced in both the jurisdiction and the subject matter of the alleged contraventions. Third, complex issues of interpretation and interaction of the national employment standards, modern awards and enterprise agreements often arise. The area can also attract contractual disputes, which require determination, and high-stakes issues of accessorial liability and set-off claims or cross-claims. And sure, while the rules of evidence and procedure don't strictly apply, this is no pyjama party. In determining small claims, the court must exercise its powers judicially and will be informed by the principles of procedural fairness and natural justice. And an applicant still has the burden to establish their claim on the balance of probabilities, which tends to require evidence of rational and probative force. A grasp on these niceties of litigation, or so-called niceties of litigation, may be considered of assistance to the court. Fourth, the statutory time limitation of 6 years means that even small claims can require a decent volume of evidence to establish the essential facts. And fifth, the court may allow the originating papers which define the claim to be amended at any time on sufficient notice. Now, in saying all of this, it must be acknowledged that the jurisdiction was established to and is bound to operate in an informal manner and without regard to legal forms and technicalities. The experience of our court is that is indeed how it operates. And if I could ask for the next slide. The numbers bear this out. Anecdotally, of those that proceed to the Federal Circuit and Family Court as a small claim, 50% proceed to first and final determination of a registrar within 6 weeks. That number includes defaults. And 80% are determined by a registrar within 6 to 12 weeks. This is possibly one of the highest efficiency rates in our very busy court, and I'm sure those in attendance today will join me in acknowledging the hard work and excellent work of our registrars in this respect. Of the number of claims finalised in the past few years, which you can see on the slide there, you'll also notice that a significant backlog was cleared by 2021, and there has also been a low instance of, but gradual increase in casual conversion disputes. The ability to access a higher threshold and track record of fast outcomes mean it certainly is possible that we will see more underpayment claims brought under the small claims procedure going forward. So let's draw back the curtain on the process and take a look at the pathway of a small claim in the Federal Circuit and Family Court. On the next slide, please. Depicted on the screen is a basic diagram of the pathway, which is a little different to that which Judge Forbes described in relation to general protections claims. The way it presently works in small claims is this. When an applicant indicates on the application form that they want to proceed as a small claim, the matter is referred to the small claims list for a first assessment or triage, which is typically conducted within 24 hours. Most progress straight to first and final determination. There will be standard instructions or directions in accordance with which the parties may exchange paperwork, but this will not be required and it won't be ordered. And for the majority, there will be no formal case management or interlocutory steps, and the matter will be heard and determined by the registrar exercising their delegated powers at the first court date, which, as I said earlier, is within 6 to 12 weeks. Where there is a degree of complexity, there will be an early case management proceeding, and for complex cases, there is the opportunity to request mediation or referral to a judge. However, those options will naturally extend the process and have seen little take up to date. In fact, if you're referring to a judge, I've noted there it extends potentially off the page and is an unpredictable time frame, unfortunately. Now, in the past, there's been less than 30% of cases have progressed to mediation and fewer than 5% referred to a judge. Suitability for referral to mediation is assessed on a case-by-case basis, having regard to factors such as requests of the parties and the complexity of the case and the estimated hearing duration. Referral to a judge is at the discretion of the presiding registrar and includes considerations around novel questions of law, test cases, and again, the hearing duration. The procedure that the court then adopts at the determination of a small claim is a similar process to that which you may have experienced in some Fair Work Commission claims where informality may be required. The court still has a preference that evidence be put on by way of affidavit, but to the extent that it's fair, will adopt a flexible approach to the provision and receipt of evidence. Parties are often sworn in before addressing the court, and that is to assist in flexible management for particularly self-represented litigants who may not understand the distinction between submissions and evidence. The court may also adopt different approaches in respect of cross-examination, including reasonable assistance to a self-represented litigant to ensure that questions are not repetitive, harassing, or otherwise unfair. Reasons tend to be delivered ex tempore, and parties will be given leave to order the transcript. Requests for review of a registrar's decision are relatively rare, but on review by a judge, the hearing is conducted de novo or afresh. On the court's data, it's too early to tell whether the instance of applicants electing to proceed by way of small claims has yet risen. Whilst the quantum itself is not determinative of complexity, the expansion of the jurisdiction is expected to result in some developments, and I'll pose a few questions in this respect. For example, will we see a multitude of individual claims against the same employer with similar factual bases and common representation, which by the statutory bounds are required to be treated individually but could be run as test or concurrent cases? Will we see a greater instance of requests for use of traditional court procedures such as subpoenas and discovery? Will we even see a rise in set-off or cross claims? Are we likely to see more claims by unions as direct applicants? And will we see development in the regulator's approach? And by that I mean where there has in the past been pursuit of general deterrence across specific industries through prosecution of compliance notice contravention claims, will we see a new focus on recovery instead of the alleged underpayments that ordinarily underlie a compliance notice and often otherwise go unresolved? Whatever the case, the small claims procedure will continue to develop as these issues arise for determination in cases before the court. And just on the next slide and the final slide for you tonight, from me at least, for those interested to read more on the jurisdiction, the first two cases extracted here address matters of practice and procedure in small claims where the rules of evidence and procedure do not strictly apply. In Bodycote, our colleague Judge Kendall considered the issue of a set-off claim in response to an underpayment claim, brought as a small claim, and the question of whether there is any limitation on the court's power to make a declaration, which relief was ordered in that case. In the case of the Fair Work Ombudsman and PTES, the erudite and present Justice Snedden considered when it may or may not be appropriate for the court to make a declaration. And in the case of Nino and Cooksall, my learned colleague Judge Forbes considered the issue of jurisdiction to make a compensatory order against an accessory in a small claim, and in that case, a director of a company who was found to be involved in a contravention of the Act. In summing up, for the reasons outlined, the case law in this area is likely to develop, and small claims, it seems, are an area to watch.
Thank you, Judge Forbes and Judge Mancini. Now, our next two speakers are prominent barristers from the Victorian Bar who have strong practices in employment and industrial relations law. They will discuss the emerging topic of class actions in this area. Please welcome Jonathan Kirkwood SC and Siobhan Kelly.
Good evening, everybody. I am going to address first on some emerging issues in class actions where we have parallel proceedings, and then Jonathan is going to address on some aspects of costs in class action proceedings. And if we can perhaps bring up the first slide, please. If we could move to the next one, thank you. As employment class actions increase, and they are increasing, they now represent about 19% of Part 4A filings in the Federal Court, it's becoming increasingly common to have multiple proceedings running at the same time, where we see perhaps a regulator bringing a claim under Section 539 of the Fair Work Act in parallel with a Part 4A proceeding. And in recent times, we've also seen the phenomenon where we have regulatory proceedings, Part 4A proceedings, and also union proceedings under Section 539 in relation to the same underlying claims for compensation for loss or damage. And what that means is we actually have 4 types of potential proceeding that can be lodged and potentially run in parallel. The first, as you'll see on the slide, are regulatory proceedings. The principal body that would commence those proceedings is the Fair Work Ombudsman, who's got standing to do so under Section 539 of the Fair Work Act. These are non-Part 4A proceedings, and they can be commenced on behalf of some or all of the affected employees in relation to a particular alleged contravention or contraventions. We then have, as the next category, registered organisation actions. I will call them union actions, but that is generally what they are. For ease of reference, that's how I will describe them. Again, these are applications brought using the standing granted under Section 539 of the Fair Work Act. And again, these can involve some or all of the persons who are affected by a relevant contravention, and that is so whether or not those individuals are or are not members of the relevant organisation. The third type of proceeding that we are seeing commence now are union class actions. These are Part 4A proceedings, but I am calling them union class actions because they are funded by the union. They don't have an external litigation funder who is providing the resources or the financial backing. The union itself is providing that resourcing. And again, we can have classes comprising some or all of the affected employees, including members and non-members. And then more traditionally, what I will call for the purposes of tonight, a funded class action, where we have a lead applicant, a law firm in support, and there is an external funder who is providing the financial support. Again, can involve some or all of the affected employees, whether or not there is any relevant union membership. When these types of proceedings are brought in parallel and they overlap as to the type of relief claimed in relation to the same or similar contraventions, the immediate question that will arise for practitioners is, should one of them be stayed or should they all run together? And if we can move to the next slide, please. Follow on to the next one. There are a range of things to take into account if you are asked to advise on whether or not a proceeding should be commenced or whether or not an application should be brought to stay existing proceedings. There are a large number of factors that would weigh into your consideration of that question, but there's a couple that I want to identify and talk about specifically this evening. The first is that the identity of the applicant is going to matter. The regulator, the Fair Work Ombudsman, has an important public function that it is discharging when it commences proceedings to enforce the Fair Work Act. I would think it would be a brave person who attempted to persuade this court to stay a regulatory proceeding. Perhaps not impossible, though, having regard to the time at which a regulatory proceeding is brought in relation to the commencement dates of other types of applications. In terms of union actions, which are commenced not under Part 4A, but under the Section 539 jurisdiction, again, we've got a public interest consideration here. That standing is conferred on registered organisations to enable them to assist with the important purpose of enforcing the Fair Work Act. And that will be a matter to take into account when considering the likelihood that a proceeding of that kind either ought to be the lead proceeding or perhaps might be the subject of an application for a stay. Allied to that, an emerging issue, and one that perhaps will arise more frequently, is that registered organisations who commence under Section 539 are bound to act in the interests of their existing membership. They are not necessarily bound to act in the interests of the persons on whose behalf they claim compensation or relief, and that may well be a matter that has a role to play in considering which proceedings should advance. Against that, we have individuals, so lead applicants, in a Part 4A proceeding. We would call them lead applicants. Under the Section 539 jurisdiction, they have standing only where they are a person affected by a particular contravention, and that has a potentially limiting impact on the types of applications that can be brought where there is an individual as the lead applicant outside a Part 4A proceeding. And of course, commercial interests of funders, which we'll talk a little bit more about. All of those things are going to be relevant considerations when a court comes to consider whether or not proceedings should proceed in parallel or perhaps whether one or more ought to be stayed. Next slide, please. The second question to be considered is one that's recently arisen in the McDonald's litigation, and that's the question of whether or not Part 4 of the Fair Work Act operates as a code in relation to the enforcement of contraventions of civil remedy provisions of the Fair Work Act. That would, if it were the case, involve an implied exclusion of the Part 4A processes under the Federal Court Act. If anyone has wondered about that question, and judging by your faces, I don't think too many of you have, but you need not wait particularly long because the question is presently reserved before the full court of this court in Elliott Card and McDonald's. And so when you all go home tonight wondering and pondering that question, you will not have to wait long, I hope, for the answer. Of course, if the answer is yes, that it is a code, then that will have a fairly significant impact on the way these proceedings can be brought and prosecuted. Next slide, please. Next, it would be necessary to consider the scope. One of the challenges, if you are looking at either bringing representative proceedings using the Section 539 jurisdiction or Part 4A class action proceedings, is that the Fair Work Act allows for multiple causes of action in relation to the same conduct. And to give an example of what I mean there, an underpayment, or perhaps a contravention, I should say, of Section 45 or 50 relating to an underpayment will almost always carry with it a failure to comply with the record-keeping provisions. So there are many ways in which a proceeding can use the same facts to generate multiple contraventions without necessarily increasing the relief or the ultimate compensation that is sought on behalf of a group or a class. And that means that there can be a divergence or a discrepancy in the number and type of claims that are brought. A streamlined model looks only to bring the strongest claims and those which are most likely to result in relief for the group or the class. The more expansive model looks to cover the field by including any and all of the available causes, whether or not they sound in a different type of relief or perhaps merely the additional potential for penalties. There's also then the role of accessorial and franchisor liability. Again, we see two streams here. One model looks to proceed against the minimum number of respondents possible to achieve the outcome of compensation for a group or a class. That, for example, might look to sue a franchisor but not franchisees using the accessorial liability provisions or franchising provisions. The alternative is to look to include everybody who might be held liable for a particular alleged contravention. And again, the streamlined model sees that the limited number of people brought into the proceeding. The more expansive model would look to include a potentially large number of respondents, depending on the nature of the employment environment. There's also then, continuing that theme of streamlined models or more expansive models, the interaction between the Fair Work Act and potentially remedies under other legislative regimes, common law causes, and of course, the desirability of ensuring that to the extent possible, we are generating issue estoppel in relation to as many respondents as possible on as many issues as possible. So one thing that will always be looked at is this balance between achieving finality as much as we can against the size and scope of proceedings and how long it might take for them ultimately to come to a final hearing. Next slide, please. Funding arrangements, this is fairly traditional, that funding arrangements are of significant interest to the court in standard, what I might call carriage fight applications. They've got particular emphasis in the types of employment class actions or employment proceedings that we are talking about tonight. A privately funded class action will, of course, look to spread the cost of that funding across what is recovered on behalf of group members. A privately funded union action, whether under 539 or using the Part 4 processes, will involve the union bearing the cost of running that case. And depending on which model is chosen, you can immediately see that that is a matter of particular interest to the court when it is assessing which proceeding ought to be allowed to proceed or whether they should run together. Next slide, please. Cost recovery is related to this funding question. And again, it's going to be of significant interest to a court when it confronts these questions, or to you as practitioners when you confront them in the advice that you are providing, perhaps to funders, perhaps to potential applicants, perhaps to clients in relation to matters already on foot. Where 570 attaches and we have the presumption against costs, the court will be interested to know who is bearing the costs and how are those costs to be passed on, if at all, to the members of the group or the class. And that again has two streams. A union or a regulator who is choosing to bear the cost of litigation will, on the one hand, have an argument that they are not passing those through to the group or the class, which is in the interest of the group or the class. Against that, a proceeding that is likely to be long and complex and expensive might be said to be better resourced by an external funder who's got the financial resources to see the proceeding through to the end of litigation in the way that it ought to be conducted. Two vexed questions that will be central to these issues when they arise. One is whether, in which proceeding is compensation going to be recovered? If you have multiple proceedings and overlapping groups or classes seeking the same relief, compensation needs to be ordered in one of them, potentially multiple of them, but that is an issue that will require early attention. Whether or not it is a union action, a regulator action, or an externally funded Part 4A proceeding, parties will want to know at an early time whether their proceeding is the one in which group members or class members, where it overlaps, are going to ultimately receive their compensation. On the one hand, those applicants who are serving the public interest function of enforcing the Act will want to see the vindication of their efforts. And on the other hand, funded Part 4A proceedings, the ultimate funder, will want to know that they have the prospect of recovering the legal fees that they have expended. And of course, the court would be anxious, I'm sure, not to have proceedings that are being run where there's ultimately the expenditure of legal fees, time and cost, but no recovery. That issue is acute, of course, also in the context of penalties, particularly when you have regard to the principle that a person cannot be penalised twice for the same conduct. In large systemic underpayments, for example, it might well be the case that despite the size of the available compensation, there are a relatively limited number of contraventions. When you can only penalise once, those penalties will need to be allocated to one or more proceedings. And the way in which that can and is to be done is something that needs to be looked at an early stage. Next is the question of efficiency. This, of course, will loom large when we look at how parallel proceedings are to be dealt with. And of course, here we see the collision of Part 4A proceedings and the supervisory function of the court and the tendency to have intense case management of class actions because of the particular processes that are required against Section 539 proceedings, which of course are within the supervision of the court, but don't attract the same mandatory processes such as opt-out notices to group members and the like. There is an efficiency argument to be made both ways. On the one hand, the intense case management processes of Part 4A and the supervisory jurisdiction of the court can be particularly important in large proceedings where we have the interests of individuals at stake. On the other hand, they do potentially add time, and time is cost in the context of proceedings. And so they are matters that will also require consideration. Other things that are going to factor in here are the quality of the originating processes, having regard to what His Honour Judge Forbes said to us a moment ago. They are not perhaps always what they ought to be. The degree to which parties can cooperate, how it's proposed that a final hearing is going to be run, and then the question of those conflicts of interests that I have described. It's a very brief overview, but these are the types of issues that you will need to think about if you are involved in advising on these questions or potentially acting in proceedings where these issues are going to come up. I've got two final slides and I had 12 and a half minutes, and I'm sure that I have used those 12 and a half minutes on a barrister's estimate, and Jonathan, my leader, is looking at me. So let me just give you the next two slides quickly and then I'll hand you over to Jonathan. Sorry, next slide after that. Joint case management. Let us assume there is no stay. We are all proceeding to trial together. Interests of justice considerations loom large here. These processes need to be tailored to remove and reduce cost, to make sure there's efficient resources, use of the court's resources, and we're achieving finality. The key things to note are that early issue identification is going to be critical. If it is your vehicle and your case that you wish to have the lead, even in a jointly run proceeding, the very first thing you need to do is to deal with the question of issue identification and to ensure that if you've got a Part 4A proceeding, your common questions continue to provide you the necessary jurisdiction. And again, those questions of how we balance Part 4A supervisory jurisdiction and the Section 539 jurisdiction will loom large here. Don't forget also that if we are jointly case managing proceedings but potentially headed to separate trials, there is always the risk of an apprehended bias issue arising where you have a single judge case managing proceedings. If that judge goes on to hear one proceeding first, they are likely to face a question of apprehended bias in relation to a second or following proceeding. And finally, before I hand you over to Jonathan, assume that you get your competing proceedings to a trial. We have the next slide. They are being run together. You will find the importance of clearly defined issues is critical. The use of agreed representative sampling to make sure that we have covered the field is critical. And then you will need to turn your minds to issues such as, is the evidence in one proceeding going to be evidence in all of them? And if there are exceptions to that, are they clear and agreed? How to manage cross-examination, multiple applicants, multiple sets of lawyers, and how that is to be resolved. And there are appropriate orders that can be made. Cooperation among practitioners is very important in these types of proceedings where we potentially have conflicting submissions about the law. And again, coming back to this question, the court will ultimately need to assist the parties to deal with this question of in which of these competing proceedings is compensation going to be recovered and are penalties to be paid. I know it's a high overview and in 12.5 minutes, that's how it needs to be, but these are the types of issues that we are starting to confront in employment, large proceedings and class actions, and the types of things that you might want to have in the front of your minds if you're called on to advise on these questions as these proceedings more frequently come up. And with that, I'll hand you over to Jonathan.
Thank you very much, Siobhan. Well, look, I was going to talk about a few issues to do with the funding of employment law class actions. Now, of course, the funding of any action in a no-cost jurisdiction is one that employment lawyers have been familiar with for years, long before class actions came on the scene. But when one looks at the decided cases emerging from the Federal Court in the last 2 or 3 years, one's struck by how many of them concern who's paying for the litigation. A couple of preliminary points. The first is that the court in recent times has now held quite firmly that class action applicants have to be legally represented unless the court gives leave otherwise. And coincidentally, one of the first case in which this was held was an employment law class action, the Wilkinson case. And that requirement's informed by a couple of considerations. The first is the court depends on lawyers ensuring that class action applicants meet their fiduciary duties to group members. And secondly, class actions are procedurally and substantively complex and almost impossible, one would have thought, for an unrepresented litigant to handle. And if we can just go to the next slide, there's a bit of a laundry list of the procedural requirements in class actions, which even with Fair Work Act claims at the simpler end of the spectrum will inevitably add to the costs of bringing a proceeding. If we can go to the next slide. Another sort of preliminary or overarching issue is that when one looks at these various decisions about miscellaneous funding or cost issues, there are a number of themes that emerge and which really permeate the court's approach. The first is that these are claims for minimum statutory employee entitlements, and that is very influential in the court's approach. They're not claims by institutional investors for a drop in the share price. They're not claims for damages for disappointing holidays. Important as those things are, they're claims for wages for the most part. The second theme is that Section 570 of the Fair Work Act, as we all know, restricts the making of costs orders against parties except in very limited circumstances. And the third consideration is that the Fair Work Act unusually confers standing on individuals and registered organisations to seek civil penalties, which is said to imbue these sorts of proceedings with essentially a public interest element, because they contribute to the enforcement of the statute and the deterrence of future contraventions. If we can go to the next slide. So these are the topics I was just going to touch on, ranging from cost disclosure before an action is commenced, through security, settlement approval, and finally judgment. So if we can go to the next slide. Cost disclosure. Now, it's obviously a given that the applicant's lawyers comply with their obligations under legal profession legislation, including in relation to cost disclosure. But in some recent settlement approval decisions, which are listed there, the court's also made clear its expectation that an applicant's lawyers should also advise a prospective applicant and prospective group member clients of, first of all, the risk that any amount paid in damages or penalties on a favourable judgment will be entirely subsumed by irrecoverable legal fees. And secondly, they should be advised of the availability of other mechanisms in the Fair Work Act for pursuing claims other than by way of a representative proceeding, namely via the Ombudsman or a union or an individual claim. Now, while the court recognised that that won't necessarily lead to enforcement action by the Ombudsman or a union, in every case, the court emphasised the importance of prospective applicants and group members being informed of these options so that they can explore them, given the potential for legal costs to erode their entitlements if recovered. If we can just go to the next slide. Now, once a class action's commenced, a respondent's first reflex is always to consider asking for security for costs. And in a commercially funded class action in a cost jurisdiction, security will usually be ordered and paid by a funder. Now, in Augusta Ventures and Mount Arthur Coal case mentioned at the bottom there, the full court confirmed that this power exists in a Fair Work Act class action as well, but declined to exercise that power by reference to a number of considerations which suggest that it's generally unlikely that security will be ordered in this kind of case. And the first of those is the disconformity between ordering a security against a funder and the protection from costs that an applicant enjoys under Section 570. This disconformity arises, of course, because if the funder doesn't provide the security, the usual consequence is a stay or dismissal of the proceeding, and that consequence is visited on an applicant who, in the ordinary course, wouldn't be exposed to a costs order at all. The second consideration is that the costs of any security are likely to be passed by the funder onto the employees and impede or erode the recovery of their statutory entitlements. And the third consideration, which was mentioned by Justice White in that case, is the public interest in applications being made for civil penalties to enforce the statute and deter future contraventions. If we can go to the next slide. Now, given the potential for rapidly diminishing returns as a proceeding progresses and costs increase, it's natural that many Fair Work Act class actions will settle. And at that point, the court will be presented with a request for orders approving the deduction of various amounts from the settlement fund as part of settlement approval. If the case was commercially funded, the funder will no doubt be asking for a commission to be deducted, which was the case in Bradshaw and BSA. In that case, the court confirmed it may approve such a deduction, but observed that the approved rate may well be lower in Fair Work Act class actions than in other types of actions for several reasons. First, in a Fair Work Act action, the funder bears a significantly lower risk of being required to meet an adverse costs order or provide security for costs, which justifies a lower return. Secondly, again, there's the character of the claims, being claims for minimum statutory employee entitlements. And thirdly, there's the availability of, and indeed competition from, alternative enforcement mechanisms which involve either a lower or no cost to the employee, namely an ombudsman action, a union action, or even a no-win, no-fee action by a law firm. And this was said to point to there being lower demand for commercial funding in this type of class action compared to others. If we can go to slide 21, thank you. Now, of course, the applicant's lawyers, if we can just go back one. Thank you. The applicant's lawyers will be seeking to deduct their legal costs from the settlement, and we've seen some examples of the court very closely scrutinising the reasonableness of legal costs in this type of case in the exercise of its protective role, including looking at compliance with disclosure of cost estimates under legal profession legislation. Another feature of these decisions is the court doesn't accept at face value assertions that there should be an uplift in solicitors' fees because of the supposed complexity of the claims. The court recognises that class actions do involve additional procedural complexity, but when looked at carefully, the underlying Fair Work Act claims may not involve unusual legal or factual complexity, other than the fact that they're brought on behalf of a number of employees. We can go to the next slide. So if the case doesn't settle, sooner or later it'll proceed through a trial to judgment. And if the applicant's successful, of course, there's a prospect of a civil penalty being ordered to be paid to them under Section 5463. And naturally, an applicant will be looking to this as a potential way to meet some of the costs of the claim. And that's always been on the minds of applicants outside class actions, of course. If we can go to the next slide, it's important to remember with penalties that although a degree of cost recovery might be the effect of an order for the payment of a penalty to an applicant or union, the full court reminded us in SIAD and CFMEU that that's not the purpose of such an order. The purpose of the power to order payment of a penalty to an applicant or a union is not to compensate them for the costs of bringing the proceeding, and to exercise the power for that purpose would be to undermine the legislative policy that there be no order for costs except in specific circumstances. Rather, the power forms part of a system which recognises the public interest in enabling certain classes of persons, including private persons traditionally known as common informers, to enforce the statute and recover a penalty. So the usual rule will be where a public official vindicates the statute, the penalty goes to the Consolidated Revenue Fund, and where an applicant or a union or an individual or a union applicant does so, it will normally go to them. And because the power isn't compensatory, it's not relevant to inquire whether the recipient of the penalty would receive a windfall or profit because they've otherwise been compensated or because the penalty would exceed their individual costs of pursuing the proceeding. The court did recognise that there might be exceptions to this rule, and one example was where the named applicant sues on behalf of or for the benefit of another person, which might raise a question about whether the penalty should be paid to them. We can go to the next slide. Interesting questions are likely to arise in future about how any penalty is to be shared, firstly in a class action between the class action applicant and group members. And there's a decision there where the possibility of payment of a penalty to group members was noted by the court in a settlement context. And even more so where you might have a competing or overlapping action by the Ombudsman or a union of the kind that Siobhan addressed. And if we can go to the next slide. Now, outside the question of a penalty, it's important to be aware of Section 33ZJ of the Federal Court Act. This is a mechanism which exists to enable an applicant who is unable to recover all of their reasonable costs from a respondent to have an order made that the excess of those costs be paid from any damages awarded by the court. If we go over to the next slide, this will almost invariably be the case in a Fair Work Act proceeding, because very rarely will any costs be recoverable from the respondent. So there'll always be an excess, and the significance of this provision in an employment law class action has been recognised in a couple of cases that are referred to there. And if we can go to the last slide, this has obviously been very applicant focused because of the nature of the topic, but not to forget about the respondent. If the class action is not successful, no doubt the respondent will be thinking of ways they might be able to recover their costs. And if there's a third party commercial funder involved, they're not protected, of course, by Section 570. And the court has confirmed that it may be possible to make a costs order against a third party funder if it's in the interest of justice to do so. But in the one case where an application of that kind's been made, it wasn't successful. And again, it's because Section 570 remains relevant to the exercise of that cost discretion, and in particular, the need to ensure that any cost order doesn't operate as an inhibition on the bringing of claims to recover employee entitlements. And another relevant consideration may well be, and was in that case, the manner in which the proceeding was conducted. And in that case, it was accepted that the funder had acted responsibly and cooperatively in ensuring there was a separate question of construction heard and determined, which in the end determined the entire proceeding, so that the funder was spared on that occasion. That's our time, so thank you very much.
Thank you. Our final speakers are two prominent members of the Adelaide Bar, Kirsty Stewart and Paris Dean. They will discuss the topical issue of the positive duty to prevent sexual harassment.
Came into effect at the end of last year. Can we go to the next slide, please? So tonight we're going to, for those of you who perhaps are not aware of the duty, we're going to briefly outline the genesis of it, the reasons why it was introduced. We'll then briefly cover the content of the duty itself. And then we're going to spend some time focusing on the enforcement of the duty, because in a few months' time, the additional powers that have been given to the Australian Human Rights Commission in order to enforce the new duty are going to be introduced at the beginning of December this year. So we'll spend some time looking at those, and then we'll conclude with a couple of predictions for the duty, as well as posing some questions to you that you might want to consider insofar as how all of this is actually going to play out in practice. So we have the next slide. So the genesis of the duty, first of all, in terms of why this change was considered necessary, effectively, under the old framework, no action could be taken against an employer before the actual offending conduct occurred. So in that sense, the system that we have had up until now has been a reactive one rather than a proactive. And when the Respect at Work report was released back in March 2020, what it essentially said was that, well, look, this isn't working. The frequency with which sexual harassment in particular is occurring in workplaces around the country is too high, and therefore a new approach is needed to focus on what proactive steps an employer and organisation can take, with the aim, of course, of preventing it from happening in the first place. And the particular recommendation as far as the new duty is concerned is contained within recommendation 17. The next slide. So the Respect at Work Act, of course, amended the Sex Discrimination Act in order to give effect to the new duty, and that is contained within section 47C. And what that essentially says is that an employer or person conducting a business or undertaking, being the duty holder, must take reasonable and proportionate measures to eliminate as far as possible, firstly, discrimination on the grounds of sex, secondly, sexual harassment, thirdly, harassment on the basis of sex. And in order to clarify the distinction between the two, you'll see I've included there the explanation that harassment on the basis of sex is unwelcome behaviour that is sexist and demeaning, but is not sexual in nature. Then a hostile work environment on the basis of sex, and lastly, victimisation. So as I said at the outline, this is obviously a much broader duty than one that is simply restricted to sexual harassment. You'll see from the wording that is contained within the relevant section that it picks up a couple of words and language types that we see in other areas of the law, in particular work health and safety law. And that's something that Paris will cover in a moment as well, that what is the extent to which we can glean guidance from those other areas of the law, and to what extent are matters already covered by other aspects of the law insofar as working out what it is that an employer actually has to do. So the fact that it is not limited to an employer, it extends to a person conducting a business or undertaking. That language clearly having been taken from the Model Work Health and Safety legislation, and indeed it is given the same definition as what it is there. So a wide ambit in which it applies, in terms of who it applies to. And so, of course, that's going to range from very small organisations through to your multinational and international organisations as well. And that's something that we'll look at as well in terms of, well, how does the duty differ when you've got different considerations for different types of organisations applying. The Human Rights Commission has also just last month released its guidance documents on what exactly employers need to do in order to ensure compliance. The Commission recommended during the inquiry that particular action be taken in 4 specific areas, those areas being leadership, risk assessment and transparency, culture, and knowledge. And the guidance that has been released last month builds on those areas. And in particular, what it says is that the measures that employers have to have in place go to address 7 separate standards. Those standards are leadership, culture, knowledge, risk management, support, reporting and response, and lastly, monitoring, evaluation, and transparency. Now, I've included up there the website as far as the Human Rights Commission is concerned, and all of this guidance extends to guidance upon guidance, so to speak, as well as the actual main booklet. And there's also separate resources for small businesses as well. All of that can be found on the website under the Sex Discrimination tab, and is a very useful resource as far as advising your clients as to what to do. Many of the standards that I've just outlined there, I think some employers, particularly large employers, may well say, well, what we already have in place, given what the legal framework has been up until now, what we already have in place goes to much of that, and therefore what else is it that we need to do? In my opinion, the last couple of things there, insofar as monitoring, are likely to be some of the aspects that might get more focus because it is something new in comparison to the legal framework. So, for example, employers may be required to get specific statistics together in order to report on the number of complaints, for example, of sexual harassment that there has been within their organisation. Or alternatively, it could require an employer to conduct a survey of its own workforce to get feedback from them in terms of how they feel, how employees feel that the workplace culture is. That, in my suggestion, is likely to be something quite different for the vast majority of employers. So before we look at compliance and enforcement, Paris is going to expand on that point that I just made as far as the overlapping other areas of the law, in particular work health and safety.
Thank you. And I'll address three. Can we have the next slide, which deals with three potentially overlapping areas of law? And each of these three areas are issues or areas of law that have been raised with me as areas that may call into question what the additional ambit of the new duty might be. In particular, one of the reasons advanced by some as an argument against the introduction of the proposal of the new proactive obligation is the existence of the duty of care in workplace health and safety laws. And an example of that appears at section 19 of the workplace health and safety, the national model workplace health and safety law, and also section 19 of our state's workplace health and safety legislation. And that's the primary duty of care. It provides that a person conducting a business or undertaking, and as Kirsty identified, that's the same language picked up in the proactive obligation that has been introduced as part of the reforms we're discussing, must ensure, so far as is reasonably practicable, the health and safety of workers engaged or caused to be engaged by the person, and workers whose activities in carrying out work are influenced or directed by the person while the workers are at work in the business or undertaking. As I say, it was suggested by some that the existence of this obligation calls into question both the need for and the room to operate for the new provision. In comparison with the provision under discussion today, the new provision is plainly broader for the reasons that Kirsty has identified, in that it addresses not only sexual harassment, but also a plethora of other unlawful activities, including victimisation and, interestingly, discrimination on the ground of sex. It's plain enough that a wide range of what is already unlawful sex discrimination and obviously sexual harassment could give rise to a risk to health and safety that would be captured, presumably by the existing WHS legislation. However, the new provisions capture a broader range of conduct that might not be thought to give rise to health and safety contraventions in the sense contemplated by the workplace health and safety legislation. For example, as Kirsty's explained, it will provide an obligation to proactively eliminate sex discrimination, even in circumstances where that does not give rise to a workplace health and safety issue. What I'm envisaging here are matters such as pay disparity that might not traditionally have been addressed by WHS regulators and may not rise to the level of giving rise to a workplace health and safety, a risk to health and safety, as is contemplated by section 19 of the model workplace health and safety laws. In relation to the duty to eliminate victimisation, much of the underlying conduct that constitutes victimisation on the basis of a complaint about sex discrimination or sex harassment may well already be prescribed under the Fair Work Act, under section 340 of the Fair Work Act, or under or remedies may be available under state workplace health and safety acts. Firstly, as practitioners listening to this presentation would be aware, section 340 prescribes adverse action by employers on the basis of a complaint or inquiry, and also on the basis of instituting actions under workplace law. The metes and bounds of the ability to make a complaint were addressed earlier today. Secondly, state workplace health and safety regimes often contain adverse action type protections that allow persons who've made complaints to access remedies if they're subject to adverse treatment. But of course, the difference here is that this proposal contains this legislative reform would provide an obligation to proactively eliminate victimisation and not simply provide remedies if and when instances of victimisation occur and can be proven. The prescription on adverse action at section 340, at least to the extent that that term adverse action involves threats to take action, may be seen to already provide some level of protection prior to victimisation occurring. However, plainly, the proposal, the new legislative provisions, I should say, will operate in an antecedent stage and require employers to proactively attempt to eliminate acts of victimisation, presumably before there's any opportunity for them to arise. Finally, on this topic, it's been suggested by a number of people that the new legislation may not require people or persons conducting a business or undertaking to do anything more than they might be required to do already by the defence to the vicarious liability provisions of the existing legislation. Section 106(1) of the Sex Discrimination Act provides for vicarious liability where an employee or agent of a person undertakes the prescribed conduct, and Section 106(2) provides that this does not apply in relation to an act of a kind described at paragraph 1 if it is established that the person said to be vicariously liable took all reasonable steps to prevent the employee or agent from doing acts of the kind. And apart from the fact that 106(2) refers to all reasonable steps as opposed to reasonable proportionate steps, which is the language of the new positive duty, the difference is, of course, that Section 106(2), whilst it might contemplate or embody a similar concept, did not require any proactive action to be taken. And indeed, because it operated only as a shield to liability, presupposed that there was the occurrence of some prescribed action about which vicarious liability was being asserted. I now want to turn to the enforcement of the duty. If I could have the next slide. An interesting feature of this Act arises that distinguishes it from enforcement of many other forms of industrial entitlements or protections. Section 110 of the Sex Discrimination Act makes clear that no right of action is conferred upon a person other than one which is expressly conferred by the Act. That would appear to me to be directed towards ensuring there's no, for example, civil liability for a breach of statutory duty for a failure to observe obligations imposed by the Sex Discrimination Act. And Section 110 of the Act has been expressly amended to refer to Part 2A, which contains the new positive duty, and to ensure that there can be no right of action for a breach of the positive duty other than one which is provided by the Act. The question then is, what is the mechanism for enforcement of and remedy of contraventions of the new positive duty? Section 46P of the Human Rights Commission Act permits the making of complaints regarding unlawful discrimination, and that term is expressly defined in that Act at Section 3(1) to include only conduct appearing in Part 2. But the new positive duty, of course, appears at Part 2A, and therefore it would appear there's no ability for an individual to make a complaint in relation to unlawful acts of or allegations of a contravention of the new duty in the way they are able in respect of other contraventions. The enforcement regime envisaged by Parliament appears to manifest in the new powers which are granted to the Human Rights Commission with effect from the 12th of December 2023, contained in the Anti-Discrimination and Human Rights Legislation Amendment Respect at Work Act 2022. For those following at home, despite the minimalist approach to the slides, they appear at, they will operate through sections 35B to 35K of the Sex Discrimination Act and envisage a 7-step enforcement process, which bears no relation to the way in which other rights, for example, arising under the National Employment Standards or Fair Work instruments, are enforced. Firstly, the Commission will investigate compliance with the duty, but it can only do that where it has a reasonable suspicion that a contravention has occurred. That concept might be familiar to practitioners in the room because it appears to bear, at least on its face, some analogy to Section 4813, which conditions when union permit holders can inspect contraventions. The Commission, before it can investigate, would need reasonable suspicion, and the explanatory memorandum to the Act provides that that could be triggered, for example, by complaints from affected workers, their unions, or even media reports. So there will be, it seems, it is envisaged that individuals will complain to the Human Rights Commission, but that will not be by way of any private right of action. If the Human Rights Commission forms the view that it has a reasonable suspicion of a contravention, they are then required to issue a written notice to the person conducting the business or undertaking, setting out the grounds for their inquiry, and they are unable to make an adverse finding, that's a finding of a contravention, unless the person has had an opportunity to respond orally and or in writing. Once that hurdle's cleared, if they're still of the view that there is a adverse finding, they must notify the person conducting the business or undertaking in writing, and they may, that is the Human Rights Commission, may make recommendations to them aimed at preventing a continuation or recurrence of the breach. They may, at that stage, issue a compliance notice, which will specify the actions that a person must take or refrain from taking in order to bring themselves into compliance with the positive duty. And the person subject to that notice can, at that stage, seek an internal review from the Human Rights Commission. If at that stage the Human Rights Commission still has a view that there's been a contravention, the person to whom the compliance notice is directed may seek a review in the Federal Court or Federal Circuit Court. And if the notice is still in place and not complied with, the Human Rights Commission can then seek an order for compliance with the compliance notice from the Federal or Federal Circuit Court. There is, for completeness, a provision allowing the Commission to accept an enforceable undertaking that will be familiar to practitioners, and it presumably is intended to operate similarly to the way the Fair Work Ombudsman engages in that regard. The effect of all that regime would appear to be there's no capacity for a worker at a workplace where there is a failure to comply to commence an action for the contravention. There will be no capacity for their unions to do so. The explanatory memorandum's explanation of the compliance apparatus is that an appropriate enforcement mechanism would also ease the burden on individuals by enabling the Commission to initiate action to address unlawful discrimination rather than relying on individuals making complaints. As I say, this is markedly different from any of the compliance apparatus that appears in the Fair Work for the enforcement of national employment standards and the like, where in those areas the state, through the Fair Work Ombudsman, as well as workers, as well as unions, all have the concurrent ability to enforce duties. And we heard something about how they operate concurrently earlier in relation to class actions. The regime here appears to contemplate that an aggrieved person will go to the Human Rights Commission, or perhaps they'll hear about it through the media or another source, who will then satisfy themselves with the suspicion, investigate, hear from the contravener, maybe issue a compliance notice which is subject to internal and external review, and then engage in enforcement activities if necessary. And the Act makes clear that the enforcement activities appear to be directed towards ensuring future compliance rather than remedying the effects of past non-compliance.
So we can just move on to the last slide. So against that background, we pose two questions here, namely, will this make a difference, given what we outlined the original aim behind all of this was? And secondly, is there a sufficient incentive or deterrent for employers to comply? As far as we see it, in circumstances where there is no financial penalty that's going to be imposed for a breach of the duty itself, it is another reason why it stands in really quite sharp contrast to other areas of industrial law, and of course the rights that are available under the Fair Work Act. And of course, the penalty provisions that are available under different areas do squarely go to the question of deterrence. So this is a really quite different approach, one that's perhaps more holistic and perhaps more idealistic. And obviously it remains to be seen whether or not employers are going to get on board. Part of the challenge for that will obviously be clear communication to them as to what exactly the new duty requires of them. And another thing that struck us with that is that, I mean, it's all very well if an employer is able to hand on heart say that they have followed all of the guidance that is issued by the Human Rights Commission. Clearly, if that is the case, then you're going to be hard pressed to say that they haven't done all that they are required to do. But inevitably, there are going to be situations for different organisations whereby some of what is set out in that guidance is just simply not practical to do, or it's too expensive, or there will be some other reason why it's considered not appropriate for a particular organisation, which means they're going to obviously have to make a subjective choice as to, well, how far do we go with this? And have we done enough? And the answer to that question of whether they've done enough is ultimately not going to be determined unless and until a compliance notice is issued, because of course it's a requirement of the compliance notice that it sets out specifically where and how the employer has fallen short and what it is that the employer requires to do in order to meet that compliance. The other aspect as well is that as far as the AHRC is concerned, there has been very little, if anything, that we've been able to find written on additional resources that are being given to it in order to cope with this new duty. The current framework of the Commission's powers, which are under Division 3 of the Act, they are being taken to apply to this new duty as well. So it is, of course, possible under that framework for the President's powers to be delegated to others. Clearly, one person is not going to be able to do this, but there also, as I say, doesn't seem to be any information as to whether additional resources are being given to the Commission in anticipation of this. And of course, it begs the question as well of, well, how much of an uptake is there going to be in this in circumstances where, as you've heard, while it is only the Commission who can do the enforcement, it does have to be initiated through a reasonable suspicion, which you would think in the vast majority of situations is going to come down to an individual complaint being made. Paris, do you want to add a couple more?
I think one of the interesting questions for developments in the law will be, it appears to me there's likely to be two potential areas that require exploration and determination in this area. The first and most obvious is perhaps on review of compliance notices by the Federal Court and Federal Circuit Court. But I think it will also be interesting to see whether points are taken around the threshold for reasonable suspicion, which is, of course, the entry point for the Human Rights Commission's instigation of inquiry into this area. So the two areas I suspect to watch will be not only review, but whether, as the Human Rights Commission moves from the phase it's engaged in for the last 12 months, which is an educative function, towards enforcement and pre-enforcement steps, what arises, if anything, out of that. I also think it'll be interesting to see the extent to which enforcement activity occurs in the context of a narrower enforcement regime than we're used to in traditional industrial entitlements, and a problem that is comparatively enormous. And I think Kirsty raised earlier the statistics in relation to the number of persons who were the subject of sexual harassment in the last 5 years.
Thank you to all our speakers. I'd like to express the gratitude of the judges to the court staff who've organised this event, including Sheridan Cheek and Taylor Banfield in Melbourne, Shannon Rickman in Sydney, and Deanna Oakley in Adelaide. I would particularly like to thank my EA, Leanne Lyons, for the mountain of work she has done. She deserves a long holiday. Now, thank you all for your attendance, and for those of you in Melbourne, Sydney and Adelaide, please join us for drinks. Yes.